What are most lawyer fees for a car accident? Now, a lot of times people think of lawyers, they think lawyers are very expensive. So if you have to hire a lawyer, you may have to come up with thousands of dollars out of pocket. Maybe they bill you by an hour. There are some lawyers in Connecticut that bill 500, even up to like about $1,000 an hour. Now that's a lot of money. With injury work, like in a car accident, nobody plans on being in an accident. And so what the courts realized long ago was that in order for injured people who have been injured through no fault of their own to get access to lawyers, they said that lawyers could work on a contingency fee. And a contingency fee means that you don't owe your lawyer any money until they win at trial or settle your case and get paid. So that way, if you're really hurt, you can get the best lawyer possible for your case. Money's not an object, which makes sense because if you have, if you get hurt and you can't go to work and you've got medical bills, like who in the state of Connecticut has just $10,000 or $20,000 or $100,000 laying around to pay a lawyer $500 an hour or something like that? So the way in which it works is Connecticut fees for car accident lawyers are set by statute. There's two kinds of fee agreements. In a standard motor vehicle case, you're going to have what's called a non-waiver agreement. The non-waiver agreement is going to break down fee structures and it's sliding scale. So for most cases, it's going to be a third because it says a third of the first 300,000. Most car accident cases are not worth more than 300,000, so you could probably bank on paying a third, and then it goes down for amounts over that. So it'd be a third of the first 300, 25% of the next 300, 20% of the next 300, and then down to 15% of amounts over 1.2 million. So it's kind of like a sliding scale. You keep paying. As you reach every level, it kind of drops for the next amount of money. There's a waiver agreement that's used in more complicated cases involving trucks or surgeries or lots of experts or reconstruction or death. And that would really be a straight third. So it would be a third on any amount. So say the case was worth $6 million. If the plaintiff's firm was successful in recovering it, their fee would be $2 million at the end of it. And there's some differences in the languages of those agreements. One of which being if it's a waiver agreement and the case loses, then the client does not have to pay the firm for the expenses. And expenses in big cases can be very high. The most we've ever had in a case was about $350,000 of expenses that our firm advanced out to experts. And because if that case was on a waiver agreement, we would, if we had lost, the firm would have paid it, not our client. So that's sort of a little bit of a nuance. So the straight answer to your question in almost all cases is a third. But as always, talk to your lawyer. Make sure you understand what you're signing. With any fee agreement, sometimes they're referred to as retainers or client agreements. Make sure you know what you're signing and get an answer to it. But know in general, you're not going to have to come out of pocket to get that help. You're going to get a free consultation at my firm and many other firms. And as always, if you have any questions, give me a call, 860-471-8333.